All right, so as I said, my name is Melissa Francis. I am one of the associates at Zelmansky, Danner, and Fiorito. And tonight we are here to do a question and answer roundtable with our attorneys and you. We did have a lot of pre-prepared questions that were sent to us, so we are going to do those first. If we can't get to all of them, we will try to figure out a way to get answers to Amy so that she can get them out. As Amy said, we are recording this for Canton Cable. Once it's recorded and edited, the cable is going to send me a copy and it will be put on our YouTube channel. So without further ado, the first person that we brought tonight is our partner, Ed Zelmansky. Ed has lived in Canton for decades and he's very familiar with Canton. He is actually my mentor. I decided to become an attorney when I was 5 due to Ed. So he is knowledgeable. He is a wonderful person, and I'm going to pass the microphone to him, and he can introduce Tracy Danner Bond.
Thank you. Is this good? Okay, thank you. Well, good evening, everybody. Thanks for taking the time and coming out and bringing your problems with you. I'm Ed Zelmansky, and I'm one of the partners at Zelmansky, Danner, and Fiorito. Said I was a Canton resident for over 40 years now, and it's a wonderful place to live, ain't it? And we have a number of our attorneys here with us this evening. On my left, my partner Tracy Danner Bond is joining us, and on my right, my other partner in our East Side office in Mount Clemens, and has driven the long way today to come and join and help out. And Richard Wagner's here from our East Side office too, on the end, okay? And Richard brings a whole lot of experience with him. And helping out, and of course, Melissa. 10 years from law school. And so, yeah. I don't know, so without further ado, and we have Officer Wagner from Canton Ordinance to help out here. Good number of questions came in, and very good questions, all of them. Some of them I'm going to say got a little personal to communities, and so we're not going to get into those personal elements of your problems this evening in a public forum. We can answer general questions about things and give you ideas of the general legal principles that govern your communities. But a couple things that I saw associations are having, so please understand that, and we can have private discussions at some later time for some of these things. And without further ado then, the questions then, Melissa? And then the rest of them we will cast. Thank you.
All right, so the first set of questions is about association financials. The first question is, what's the best way to handle delinquent payment of association assessments? So the first thing any association needs to do, you need to look at your bylaws to see what the protocol is for delinquent assessments. And then as a board, you need to make a collections policy and determine how those delinquent assessments are going to be handled. When are you going to send the first delinquency notice? When are you going to send it to an attorney? What steps are you going to take after it's sent to the attorney? The normal protocol is for the first couple months of delinquency, the property manager, or if you're self-managed, the association will send out the delinquency notice. Once you're 3 months past due, it'll come to the attorney, and the attorney will send out a notice. And then after 30 days, a lien will be placed on the unit. So after the lien is placed, then you can proceed with foreclosure if the situation warrants that action. So second, when all efforts to collect delinquent assessments fail, including recording lien on the property, what is the next step? So depending on the balance, the next step would be to proceed with foreclosure of the lien on the unit. So our office, we do foreclosure by judicial foreclosure. So what we would do is we would file a lawsuit against the owner or the co-owner of the property, and we would get a judgment allowing us to foreclose on the property. You can do a district court action to get a money judgment, but money judgments are sometimes very difficult to collect on. So if you do the judicial foreclosure, you can get a money judgment and you can get a judgment to be able to foreclose on the property. So that's the first two questions. And the third question is, what is the reserve requirement for condominium and homeowners associations? So the Condominium Act requires that 10% of your yearly budget be what your reserve is. Of course, we recommend that you do a reserve study where a company will come in, will assess your common elements and determine how much money you should have in reserves, and then you can work towards that. Because 10% of most budgets is very low and will not get you through repair or capital improvement.
I just wanted to ask you a question. Were we talking at the beginning when you started, were we talking about associations generally, or are we talking about condos? Condos or HOAs? Like, okay. So, I wanted to just add something if I could. Like, that is the process that she's outlined, the process that we usually use at our firm, which is to file a lawsuit for judicial foreclosure in circuit court. There's a difference, though, when you're talking about HOAs versus condos. Condos have a very specific statute and remedies in the statute, as well as laws that are very, detailed and expressed, because there's a condo act. When you're an HOA, there's no HOA act, right? So if you're an HOA, it's not a condo that is just, you have declaration of covenants, everything's going to depend on what your documents say. So all your remedies are going to be come right from your covenants. So if you're talking about, do we have the power to foreclose our lien? You might not. You have to look at your covenants to verify that, right? Because in the condo case, it's automatic because that's state law. In the HOA case, it depends on your documents, and there's other limitations. Many older HOAs don't have a lot of remedies in their documents, especially the right to recover their attorney's fees and costs, which is another big thing. So you want to make sure you have all those things in your documents, and if you have older documents, you really want to fix them. But my point is just to make, there is often a significant difference between the HOA setting and the condo setting, and that's primarily a function of the fact that condos are governed by statute in Michigan and HOAs are not. And I can give it back to you, or I don't know if anybody else wants to ask.
Just further to what Greg said, as a backdrop to all of the questions, each of your communities will have its governing documents. In a condominium association, you have the master deed and bylaws. HOAs, you have a declaration of covenants and bylaws maybe. And so each community will be unique because you have your own unique governing documents. And so many times, if you have a question that sounds general, our answer will be, well, it depends on what your documents say. And so if you're on the governing board of a community, you really need to be familiar with what your governing documents provide and require of the members there.
Reserve study. Studies, there's no requirement at all, like for HOAs, if you're not a condo, to put money away. That again comes from state statutes for condos. So, HOAs, usually have a lot less maintenance obligations anyway. I mean, usually you're only responsible for like snow plowing and, maybe you have some landscaping, maybe a park, but usually you're very often in an HOA where it's just, detached homes. There's not a lot to do, so there's not a lot to plan for, but you still do need to plan. Whether you want a full-blown reserve study, maybe for an HOA with very few responsibilities, that might not be necessary to have a professional reserve study, as opposed to a setting where you have a condo where they have lots of expenses, lots of things to plan for. So, again, HOA is very, very different than condos, but no legal requirement as far as a percentage to save money in a bank account for HOA, but you still need to be prudent as a board and plan for those expenditures or capital, replacement costs you may have in the future, whatever those may be. So.
Possible to maybe turn off that light up there? Because
Yeah, it's real
hard to see the screen.
Sorry, we can't. I think all the controls are behind you if you're Melissa.
Thank you.
But it's also on your handout, correct? You can put the slide up. We'll take care of it.
I don't know if that helped, but all right. So the next section is about insurance and liability. So the question is, what types of insurance should an association carry, and what should they cover? So who would like to take this question about insurance? Tracy, do you want to take that question?
Insurance is a fun thing to deal with. First step, again, like we've talked about, the first step is to look at what your documents say. Oftentimes, people don't realize what their documents actually say, and that's going to be the roadmap to what is covered by the association, what is covered by the co-owner. So if I can just have a show of hands, how many folks do we have from condo associations? All right, and the rest of you HOAs. Especially the folks that have condos, you really need to take a look at those documents. And I know they're really hard to read. And that's one of the things that we do as a firm, and try to redraft documents so that they're easier to understand and so that it's easier to take a look at these sections and understand them yourself without us having to explain what they mean. But there's going to be a section in your condo bylaws that specifically address insurance. Scott and I liability insurance, $1 million worth of coverage, you've common elements, and your documents may also say that the association has to ensure things in the association to ensure. So take a look at your document specifically. Sometimes, and I know Greg is up more so than I am on the different terms of the insurance coverage, but a lot of times the way you think about insurance is it from the walls in? Sometimes your documents actually say that the association is responsible for ensuring betterments and improvements, which is a very scary thing, because what you might have in your condo could be very different from what your neighbor has, but yet the association, according to your documents, has to provide insurance coverage should that get damaged. So make sure that when you have a question about insurance, take your policy to your insurance agent to make sure that you as a co-owner have enough coverage. So you as a co-owner need to make sure that you have an HO6 policy, and that coverage must include sufficient coverage of what you have in your unit. If you have those upgrades, if you have Brazilian wood floors, if you have the granite or marble countertops, make sure that your coverage is sufficient for what you have in your unit. We also recommend the coverage if there's any type of additional assessment that might be loss assessment coverage. That's what I'm thinking of. make sure that you have the right coverage for your unit. One of the first things that we look at when there is an insurance question is not who caused the damage, is what is damaged and who is responsible for maintaining that item, whether it's a common element or something within the unit. Taking a look at the association's deductible amount is very important too. So that way you know if the association's insurance deductible is $10,000. If you're a board member, you know that any claim below that $10,000, the association needs to provide coverage for that, not through the insurance, but through the funds of the association. So in other words, when you're looking at your budget, working with your property manager, or if you're self-managed, working amongst yourselves, you need to take a look at what has your loss history been and how much do we need to budget in case there are losses that we need to cover if they're less than our deductible amount. And the higher, like any other insurance, the higher your deductible, the lower, or the higher the deductible, the lower the premium. So take a look at what your premium is versus your deductible, and you may want to make adjustments within your budget. If you are a landlord co-owner, so you rent your unit, make sure that you have changed your type of coverage with your insurance agent. So you as a landlord need to get special rental insurance for your condo, and you also need to make sure that your tenant has rental insurance as well. Same thing if you're a homeowners association. Make sure that those renters and the homeowner in your home have renters insurance. Associations insurance for HOAs is going to be a lot less because there are fewer things that need to be covered. Other insurance issues that we need to talk about is fidelity insurance coverage, directors and officers coverage. Your documents should require that your association have directors and officer liability coverage so that you as a board member are covered in case you are sued as a director. That coverage is not going to kick in if you have done something negligent, if you have, even if you make a mistake, if you did it with due diligence and you made the right decision based on the information that you had, but that ended up being the wrong decision to make, you're going to have coverage for that. It's when you have negligently made a decision for the association that's exposed you for liability where the coverage will not apply. Do you want to add to insurance discussions?
We had a question about, thank you. We had a question about workers' compensation. Does your association need workers' compensation insurance even if you don't have any employees? And we've talked to insurance agents about this, and they've gone both ways, back and forth, changed positions sometimes. But what we've concluded is that it's worthwhile, even if you don't have employees, to make sure that your insurance covers workman's comp. It's not very expensive on an annual basis, particularly if you don't have any employees that you think of, then you're not going to have any claims. What we're concerned about is protecting you against that situation where, in fact, uninsured worker is on the premises and is injured. And, so if there's, okay, and let's say a serious injury, the tendency by the law will be to look to find some coverage to make sure that that injury does not go uncovered. And so someone, even though you say, well, that person wasn't our employee, there may be legal counsel arguing that, well, yes, that person was your employee, and they would have their reasons why they would try and make it so. So it's just worth the ounce of prevention to protect you from an uninsured claim that may occur because of an injury to a worker on your premises, to have workman's comp coverage. And I have a question up here.
I just have a question because we have an umbrella insurance for our home in case anybody comes into our home for working. So is that kind of like what you're talking about if you're in an association and you're on the board and you have people come in to do work for the condominium, that
Well, no, workman's comp is a Michigan statutory form of insurance that is in place as the sole means of compensating workers for injuries that they received on the job. And your umbrella coverage, you really have to check with your agent to see how far that extends. It's going to differ from policy to policy. And so what you need to do is ask the direct question of your insurance agent of what coverage you have for workman's comp, and see what their answer is. If they say, yes, you do, then good. If they say no, then you want to make the inquiry. What do we need to do to get a rider for that particular coverage? And I've seen the quotes for the rates on that. It really is not a lot of money on an annual basis. And, you know, an ounce of prevention is worth a pound of cure. Yes, sir, in the back.
As an insurance agent for all of condos and homeowners, you really don't have to have the word comp. You're getting proof of insurance from whoever company you're hiring to run your property.
You should.
As in our association, nobody's hired to run our property without proper liability that we require in all our contracts. We won't hire them. So if you have that, you're saying you have to have it. You really don't.
Well,
They've got the protection to protect their employees on your property.
I mean, you're right, generally. I mean, if they have their own coverage and they provide you with the certificate of coverage, then it shouldn't be a concern. But what if the policy's lapsed? What if they haven't paid the premium? You know, you never know. That's the concern, I think, really is, you know, if there is that one case and all it takes is one where, you know, that person isn't covered for some reason. Or if, you know, it's a legal concept, whether you're an employee or not, right? So if you want to, you know, you might not think a person is legally your employee. You're not responsible for them, but you might be. Okay, so that's another problem, I think, you know, why you should have it. You know, we've gone back and forth on this over the years about do you need it, do you not? Some people say no, some people say yes. This a seminar, so if you guys really want to torture yourselves, go to our YouTube. We have a channel, actually, a YouTube channel, and it was a couple years back. It's all about insurance. There's a very specific point in the presentation where I did a co-presentation with a gentleman from Sterling Insurance, name of the company, and he said, you know, specifically on this, yes, you should, and the reasons for it are laid out in that video. ZDF condo and HOA attorneys, and you know, also, you know, people who are not even you know, being paid. You know, that's also a big concern if they're doing work. You know, if somebody volunteers to do some work, you know, we always say, you know, don't let the board president use a chainsaw to cut down the trees, and, you know, don't do that. That's not a good idea. Don't cut down the trees that are dead. And you know, there's very specific coverage that you can actually get for volunteers to cover them under workers' comp, and that's mentioned in the video. So, you know, this guy was very knowledgeable on all the ins and outs of insurance, and that's who you really want to talk to about, you know, insurance issues. But I agree with Ed. The general consensus is have it, don't have it. You should probably have it just in case.
Yeah, and with regard to your comments, sir, you said that, you know, you understood that you have to have it. No, you don't. You don't have to have it. You don't have, right. You don't have to have it. You're getting all your certificates in and everybody's on the up and up. You're working in a perfect world. That's great. That's how it should work. But what we're just talking about is, you know, you as board members are charged with using reasonable business judgment and making decisions for the benefit of the association. And so there are things that you don't have to do sometimes, and it's like you make the call. Okay? Do you have to have workman's comp insurance if you have no employees? Legally, no. But then we're talking about what's on the periphery, and that's where you as board members make the call. You can make the call not to have it, and is that an illegal decision? No. You know, it's not suggesting that you somehow are not meeting your responsibilities as a board if you don't have it, because you're dotting your I's and crossing your T's. And I don't have the confidence in the administration of associations, in my experience, to think that everybody is dotting their I's and crossing their T's.
I can't believe it.
Darn serious. Yes. We have a question from...
I did. I was going to ask under what circumstances, or people that come into your property, the HOA property, under what circumstances
Yeah, repeat the question.
The question is, under what circumstances are people that come onto your grounds considered employees?
Under what circumstances? I mean, what makes them your employee?
I think one of the things is the degree of control you have over that person and their job.
Yeah, well, in case they get injured, then you're responsible for that injury.
Right.
You said
Yeah,
in some cases
it's a
it's considered your employees and some cases
Yeah,
it's not. So
there's a statute on that, and from my recollection, a lot of it deals with. I mean, there's several components to it, but I think to a large extent is that person under your supervision, under your direction? And I don't remember all the elements of it. I'm not a workers' comp attorney. I'm not an employment law attorney, but I do know that is statutory. And you could be. I went to a seminar once where they talked even about joint employer liability, where you could have two parties be designated or construed as the employer because of the facts that apply to the law in that case. So you never want to be the employer. You always want to set it up so you're not as an association, because there's liabilities that come with that if you are deemed to be the employer, right? So that's why you always try to make it like, hey, you're a contractor. You're not our employee. You are not our employee. When I review property management agreements, I always make sure that it's very clear that anybody who comes in here is not our employee. It's your employee, property manager, not ours, not the associations. Be very clear about that. You can call them a contractor, but it's not employee. Try to be very clear about that. And whatever all the legal elements are of control over that, you want to make sure you satisfy those. But it's just. It is a concern, it is a legal concept, it is a statute, and there are tests for that, as well as, other types of laws that apply to like employment law, federal law, and there's definitions for employees for those purposes too, but.
Yeah, hi. I know we're going to run out of time at this rate, so I just want to throw a couple things in here. There's a lot of other things that you may need to consider. You need to consult with your attorneys, and you need to consult with your insurance agents. But for example, whether or not the association would need umbrella coverage, whether or not you need code compliance upgrades that you sustain a loss, and the municipality decides you need to have all sprinklers and everything in there. So whether you want to insure these types of risks and losses, whether or not you're going to be dealing with civil rights claims, whether or not you're going to be dealing with mold claims or water backup, surface water, sewer backup. So there's a lot of kinds of insurance that the association may need to consider picking up depending upon their geographical circumstances. And to go to that gentleman's point, usually when I amend the documents, I make it all mandatory that they need to have insurance, whether you're an HOA or whether you're a condo, primarily because you don't want to be sitting there with a burned out dwelling, one way or another. And not only that, I put in there that they have an affirmative duty to provide notice, to go to Greg's point, whether there is any actual or intended lapse or discontinuation of coverage, so that you're protected, because you get the certificate and you think he's covered, but he's not. He didn't make the premium payment. So you make it part of your contracts to say, fine, you gave me an insurance contract, but you have a duty to give me a notice in case they say they're going to cut you off, because then you know that you're going to have to do something. And as far as the workers' comp, it's usually really cheap. You can usually get it for like $600 if you don't have regular employees. So from my perspective, it's well worth it to at least have it. Because like Greg says, in terms of employee, you're talking about control and direction. If you've got control and direction of somebody, you may be considered the employee. The last thing that a lot of people don't think about is even vehicle insurance, whether the association has it or whether you're a contractor. You got people driving in your community all the time. They run into the sign, they knock the sign down. You want to make sure that these contractors pick it up because they got vehicle insurance coverage and so on and so forth. We don't want to always put it back on the association, because the association's got to pay a deductible, and that means you're going to have to raise the assessments for everybody to cover that stuff. So I just thought I'd throw some of that out there.
There was another question on insurance, and the question is, based on the language of the bylaw below, should the association require each co-owner to provide proof of insurance on a regular basis? And, Section 3 at the bottom there is an excerpt. And if you squint real hard or something, you might be able to read that each co-owner shall be obligated and responsible for obtaining fire and extended coverage and vandalism and malicious mischief insurance with respect to the dwelling and all other improvements constructed or be constructed within the perimeter of their unit. and for personal property located therein. So there's a mandatory obligation in this section of the bylaws requiring that co-owners shall insure their dwellings. And so it's like, well, should we ask for proof of insurance? My opinion is yes. And it is clearly the co-owner's responsibility to buy that insurance. But if they don't, then the risk is that there's an uninsured event, a fire, a flood, something like that. And then they kind of put the whole community at risk with the consequences of an uninsured loss. It might, it isn't going to necessarily become in any way the obligation of the association to fix that loss, but you've got this unit, and a hole in the ground here because a unit burned down without insurance or adequate insurance. And so,
I'm sorry, I'm the one that lived more in the ravines. We're detached. So would that even matter because we're detached?
yes, in my opinion, yes.
Be my question, is this a site condo or is it a?
Yeah, it is.
Site condo.
Yeah, detached or site condos.
Not an HOA.
It is a condo.
Condo, which is similar to an HOA because there's detached
Well,
buildings.
it's not an HOA. It's a condominium association.
Okay, right.
Detached
And
condos.
does the association do any maintenance of the structures on the
Oh,
lots?
yeah. Not on the buildings, but,
Yeah,
cut grass and all that.
I used to live in a site condo in Canton until I moved like 2 months ago. For 6 years I lived here. I was president on the board. I probably know some people in here, but it was the same deal. It's a site condo. So it's a site condo. When I say site condo, I mean your unit is just your lot, and your house is built on top of your unit. That was where I live. And the association did no maintenance on my grass or my structure. Is that what you have, or does the association do maintenance on your structures? Okay, so you have more like in the middle hybrid type style. You're in the middle, like you have detached structures, but the association does maintenance. So the question you had on this was, does this provision require the association to demand that co-owners provide proof of insurance under that provision? I mean, I don't know that I'd say that it's required. Required. I mean, well, usually there's more language to these sections that there'll be like another paragraph, and then when I do amendments, I would say, upon request, the association can ask the co-owner to produce their insurance, so that it would be very clear the association that has a right to request the proof of insurance, but it's not something the association has to do every year.
Well, I can think of an example. We have someone that's in bankruptcy.
Yeah.
And I might be a little bit concerned about that. Because they're filing bankruptcy, they're not keeping up with the outside.
Oh.
So maybe I could ask them that.
Yeah, I mean, it could be, if you're concerned they're not insuring their home. These are detached homes, so it's like if it burns down, do they have the? I guess I would need to see the rest of this as far as who's responsible for,
That's our attorney.
Oh, okay. Well, I don't get too specific, I guess, but.
Trying not to incur legal costs.
Yeah, I get it. Good try. Where? In the back? Somebody? Or-
Second row from the back.
Another question out there on insurance? Yes, well, my question was, it seemed like you were talking about something more applicable to a condo, not necessarily a homeowner's association.
Well, it depends. Like some condos are set up like regular homeowners associations.
Like if we have a neighborhood and we have a homeowners association, everybody's purchased their home.
If there's no master deed and you only have covenants, then you're straight up HOA subdivision. I agree. If you have a master deed, you're still condo. I don't care how it's set up. You're a condo. That's what a lot of people don't get. They think, oh, I have a separate house. It's my house, and nobody else owns it, and we're not a condo. It's like, yeah, you are. You have a master deed. Your lots are your units. That's how it's set up. So that's a little confusing to some people. Here, under this language, this looks like standard. Just this provision looks like the co-owner is solely responsible for insuring their entire dwelling, which is kind of what you would expect in a site condo scenario. Although where you have detached units but association responsibilities to maintain, sometimes you do see, the association is responsible for insuring the structures, just like any other attached condo. So that's not uncommon to see. So I would, need to see the rest of that. But I mean, if you wanted to make it absolutely mandatory that, the association has to ask for that, you could. But, right now, I look at this language, I see the burden is on the co-owner to get the insurance. And I think it'd be reasonable for the association to ask if, to provide proof of that because they have to have it. It'd be hard for, in my mind, for the co-owner to argue with that. It's like, well, why should I have to provide my insurance? Well, you're supposed to have it. So, anyway, anybody else on that? Or? Yeah.
So, how do you know if you're under a master deed? I mean, where do you?
Good question.
Where does that reside?
Well, it's all at the Register of Deeds. So, all your governing documents, like your master deed, your bylaws, your subdivision plans, if you're a condo. If you're in Canton, they're going to be in Wayne County ROD, Register of Deeds. So you need to search you can just put your address in, right, or your name, or name of the association. And you can find the actual covenants. If there's a master deed, you can find it online, actually.
A quick and easy way to determine whether you have your property is subject is look at the deed. And it will reference in the legal description if there's a master deed or if there's a declaration of covenants.
Yeah.
The legal description's gonna be the starting point.
Right, exactly.
And go to the Wayne County Register of Deeds.
If you can't find your documents, call your municipal assessor, give them your address, and they'll tell you where you're at.
Yeah, so it's a big difference because you're talking, statutory condominiums, master deeds, bylaws versus declaration of covenants.
Insurance policies ever cover theft from officers? Board?
That's something that I think is on the list, right, of things that you should have. It's called, dishonesty,
Fidelity insurance or dishonesty.
fidelity insurance, employee dishonesty, crime and coverage. Yes, you should have that. It should cover, I don't know what the coverage level is, like 25 grand usually. It's probably not enough, but the question is about like embezzlement situations. Should you have insurance for the association to protect you? Yeah, I would strongly recommend. We've seen horror stories of that happening, and you can't believe it. But man, if there's no insurance, how are you going to get the money back? It's very difficult. It'll take a long, long time for that person to pay you back. So, strongly recommend that. Yeah. What was that?
Condo in Mexico, but my association don't have any money.
Oh. Yeah. It's important to have that. D&O, embezzlement, or crime dishonesty, you should have that too. What else?
Just want to hit those two association liability questions. What's an association's liability?
Liability.
If they have a party and there's a bounce house and someone gets hurt, is there liability?
Oh,
for the
is it?
association?
I guess the question is where the bounce house is. Is it on Common Elements?
Association sponsored.
Okay. I can't see it. I would say there is potential concern if it's on your Common Elements. I would have a special agreement that I would have them sign before I would allow it, because of.
Her question is if the association sponsored the event.
Well, if the association sponsored the event, then it's even more of a concern, right? So either way, it's a concern. If you're because I've seen scenarios where they let people use the Common Elements for stuff, and it's like, well, you better get an agreement if there's kind of anything going on that's even remotely risky. They should agree to insure it and indemnify you if there's any injuries, right? So that is definitely a concern. You should, that'll be your liability coverage. So you want to make sure you have good liability coverage for your association.
Check with your insurance agent to see if that is covered, and if it isn't, you probably can get a special rider just for that event.
Yeah, that's a good point. You want to make sure that type of thing
So
is not
the
excluded.
first question is check with your agent, is this covered, and if that's
Mm.
no, then can you get a special rider for that event?
Special event coverage.
There you go. He's like insurance guy. Yeah, so it's definitely something to be concerned about. Anything that's on the Common Elements, swing sets, pools. Those are all like special situations that could have huge liability. If something ever happened, like in a pool, you're talking about something that could bankrupt the whole association pretty easily. Talking millions and millions of dollars. There's a client we have not too far from here where there's a situation where a person was killed when they fell into a catch basin. So it happens, and it was just a freak thing. And now they're tied up in major litigation of millions of dollars are at stake. And the question was, what happens if you don't have the insurance? Good question. What happens if you don't have insurance, or if the judgment is more than your policy? You're in trouble. You're going to have to assess everybody to pay it, or file bankruptcy maybe. But that's not my forte. But that's a real concern. So that's why you might want to dollars enough if you have a pool. Probably not. So definitely it's something that can happen, and you got to make sure you have all that types of coverage, because stuff like that happens. It does. What was the other question?
Melissa, was there another question?
It was, what if you allow a non-association sponsored event on the association? So, like, if someone's associated with the church and you allow the church to do an Easter egg hunt at your association, and someone gets hurt, what's your liability, and how do you plan for that?
Richard?
I think Greg kind of answered some of that, but.
Again, if you have a non-association sponsored event at the association, you want to make sure that whoever is sponsoring that event has proper coverage. Again, that's where your special event coverage is going to kick in. And again, call your association insurance agent. This is where if you're on the board of your association, you're not expected to know all the answers to these questions, and that's where you need to lean on your professionals. Contact your association's insurance agent and ask, what if we allow the church to come in and do this Easter egg hunt and something happens? Do we have coverage for that? And the answer might be yes or no, but also get that special event coverage requirement from the person that is going to be coming onto your property. Yes, ma'am.
So a question about that. We have a clubhouse, and part of the condo association said that members can let their family have birthday parties, other parties there. The owner is supposed to be there full time because they're there. I'm almost positive it doesn't happen. So what happens if, and there's a pond right behind the clubhouse. So what happens, obviously, then the association is responsible if somebody gets hurt.
If somebody were to get injured in that pond, we're again talking about common elements or common areas, yeah, you're all going to get sued. Everybody's going to get sued. And you'll have everybody's insurers will be involved, right? So again, that is a concern. When we're talking about these situations, I think the insurance is number one, because that's where the money comes from. So make sure it's insured one way or the other. But I would also do some kind of a contract and hold harmless release to say, we're letting you use this for your event. And if whatever happens, you got to insure it, number one. Number two, if anything happens, you're going to indemnify and hold us harmless and agree to defend us for anything. I mean, that's less valuable than actually having the insurance, because insurance gives you the money. That person might not actually have the money to pay you, and you have to sue them to enforce the indemnity. So it's kind of a secondary, it's the second best remedy, I think, at the end of the day. But the insurance is primary. But yeah, that's a concern. If you're doing stuff in your common elements, you got to protect. You got to think about it. You can't just let everybody do.
Or even in clubhouses.
Yeah. Yeah, I mean, it's common area, so, it's on your property, you'll be sued, I think.
There's a saying that insurance is there to protect the innocent. And, a lot of times the questions we, hear from boards is like, well, we didn't do anything wrong. Why should we make a claim? And the insurance is there just to protect you from liability. And, turn on your television. You got Mike, you got Feiger, you got a whole host of attorneys out there who are making their living finding ways to get money. We're going to, your insurance company isn't going to tell us no. And so that's the reality. And so when we're talking about, the prudence of having adequate insurance, isn't like, well, we're not bad people. Why should we carry insurance? Again, just keep in mind, insurance is there to protect the innocent. And so you want that coverage for the benefit of your association. And a big part of that coverage isn't just to pay claims, it's to pay for the defense against claims. So that if you have someone make a claim against your association and you have insurance coverage for that, your insurer will assign legal counsel to defend you and pay for your defense. And that's a separate issue from paying an award of damages against you. There may be some instances under insurance policies where they may not pay a damage claim, but they will pay to defend you against that claim. Again, as Tracy said, you know, these are questions that you have an insurance agent there to advise and counsel you about. What kind of coverage do you have? What recommendations are there as far as what insurance coverage you need?
Yeah, my dementia medicine kicked in here. Two major points on this. One, make sure you have rules and regulations that set forth the procedure and that you actually sit down with your attorney and make a checklist. What do I need to allow people to do this? I need insurance, I need this, I need this, I need this. So that you're treating everybody equally because you've got it in your rules and regulations. The other thing you have to be cautious about is if you're constantly opening your clubhouse to non-owners to allow them to rent it and use it, you're going to be subjecting your community possibility to ADA requirements. So you may want to sit down and talk with your counsel for your association. It's like, oh, we're going to be renting out the clubhouse and that. What do we need to do? And then you're going to have to start looking at the property to find out whether you've got ramps, with everything that they may need to be able to utilize those facilities under ADA. Okay.
One other thing I just want to mention on insurance and lawsuits, like if you guys get sued, your association gets sued, I always tell, the first thing we tell our clients is, you know, turn the lawsuit into the association's insurance company. For the first thing we always say, see if there's coverage. And why? We want to see if there's coverage for the defense, because even if, you know, I don't even really care if there's coverage for damages. I want to know if there's coverage for the defense, because then the association doesn't have to pay us out of pocket. They get the insurance defense counsel, and they step in, and if they have a deductible, they might have a $500 deductible that the association has to pay, but the rest of it's all paid for by the insurance company. So it really pays to have good insurance, and then if you do get sued, turn the claim in, you know, always turn the claim in and see if there's coverage. Yes.
So this question is going to sound really weird, but can the new association sue the old association for things that they were negligent on?
You're talking about the boards of the associations? Sure. I mean, if a new board comes in and they uncover misdeeds or other stuff that might be a legal claim, they could sue, and then, you know, they'd sue the individual board members, and they might be covered may or may not be covered under the association's policy, even though they're being sued by the association because they were board members at the time. So that gets real confusing. Richard's dealing with this, I think, right now. He's got a real complex case with a person that is on the board but is also in the lawsuit as a defendant, and we're trying to get coverage for her from the association's insurer. So, because she's on the board, so even though it can be done, and there may also be coverage in that scenario for the people if they were directors when it happened, as long as it's not excluded. They didn't do, like Tracy said earlier, they weren't grossly negligent or didn't do something criminal. You know, every policy's got a bunch of exclusions of stuff they just won't cover, and not all policies are well. So you want to make sure you have a lot of stuff like fair housing claims. Some policies, you know, it will exclude all kind of claims, and those could be big dollar claims, significant things. So you want to make sure you have coverage for as many things as possible and not have big holes in the policy.
It's not so much a question as a statement that our insurance company for our condo association, I don't know. We've been very lucky because they come out every year and assess our complex. We've had to put up no trespassing signs. We have 2 retention ponds in our complex. We've got a bridge that runs through our complex. We have signs. I mean, they're not overwhelming, but it helps. You know, no trespassing, no fishing off of the bridge because we have Willow Creek running through there. We're right next to St. John Newman Church, so we've got a lot of, they've come out and
That's great.
given us, telling us, this is what you guys need to do. Maybe you didn't pay any attention to that. We're just very lucky, and I think that helps.
Typically, bylaws will require such an annual assessment of insurance coverage. It should happen, and very often it doesn't. Just sloppy management of associations. It doesn't happen. They just maybe run it at the last minute, say your insurance is about to lapse, hurry up, sign up a new one. We've seen that a lot.
No, we had to send them pictures too, proving that we did all this stuff.
But that's a good thing.
Yeah,
It's a little work for you.
I don't care.
But it's a good
I would
thing.
rather do that than get sued.
Yeah. I mean, it's good for them too. It's less likely you'll file a claim because you won't get sued.
Right.
All right, so our next topic is fireworks. Okay, so the first portion of this question is going to go to our ordinance officer, and it's, does Canton Township ordinance require written permission from the property owner to set off fireworks? And if so, does this apply to common areas and an association? So,
Should we ask Mr. Wagner, not our Wagner, the other Mr. Wagner? Mr. Wagner.
So in Canton, our firework policy is handled through the police department. We don't necessarily require any kind of agreement between owners or the HOA with a person wanting to let them off in a common area. We do have regulations of when they can go off, but not so much as asking permission of anybody in the neighborhood.
Ordinance states that in order to do it off private property, you have to have express written permission from the property owner.
That is a law, not an ordinance. It's held through the police department, and it's last I known, it's being disputed because of the Holiday Act, I believe it's called, where they can let them off on 4th of July, New Year's. It doesn't tell us either. It doesn't allow us an area of where we're supposed to ask for permission or not ask for permission, if it's in the road, if it's in the driveway, or if it's in the yard. Okay.
But it also says you need express written permission, I believe, from the property owner. So
Yeah.
my question is, right, but if you have common areas, who is the property owner?
Great question.
The association, correct.
So if an individual owner in a neighborhood
Correct.
views that commons area as partly theirs, they're wrong, right? It's owned by the HOA. Right. So with the HOA,
Possibly.
you give permission.
That's the way I interpret it.
Okay.
Brooke and I talked about this for a project. Brooke in the back with Jordan, so she knows.
But let me add one more thing. We do have HOAs that they consider their common area, where the common area is owned by Canton Township. So that also throws a loop in there that, are you on HOA property or are you on Canton property? So that's something to also consider.
And if
And
you're
you
in
can
a
get that,
condo-
you can get that through your planning department, sorry. You can get a plot map through your planning department and it'll be defined in there.
With our HOA, I don't know about everybody else, but our documents say that every homeowner is a shareholder in the association, and they have 911 share of ownership in everything the HOA does, and everything the HOA has, including the parks, the common elements, those kinds of things. So if a homeowner lives on the parks, or doesn't live on the park, he wants to go to one of our parks and set off fireworks, he has the perfect right to do that, but he is a park owner.
He's not the only owner, though. That's the question.
Collectively, correct?
It's owned
It's a collective ownership.
It's owned by
If
the
it's-
association.
Right, if it's HOA, usually the title, the deed is actually held in the name of the association as a corporate entity. If you're a condo, it's a little different. Under statute, condos are actually owned by all the individual owners together in the condominium form of ownership. So the association of the condo setting doesn't actually own the land. The owners do together, so it's a little different,
But
the-
you're
the-
governed by a board of directors
Board of
that
directors.
makes those decisions for the association. So if you want permission to use that land that you have 1/900th share in, you still have to go to the governing board and say, I'd like to use this because it's gonna affect everybody else. And that board may tell you no.
Depends on your community.
I'm just saying what our documents say.
Yeah.
Then who cleans it up afterwards?
You, Greg. I'm not concerned about worrying anything about ours.
We're concerned about
Let them
liability.
out on our faces.
I'm sorry, who are you?
Debbie Green, you know.
Again, you have a policy and a procedure.
On our faces, and when all of our
Well,
architects and
okay.
wait a minute,
anymore.
No, but when you were for the last 5 years, you didn't do anything.
I can talk to you later if you really want to talk
No,
about that.
no, we'll talk now. You
No, I
can't
won't.
face anybody. All you're doing is giving everybody a bunch of crap up there.
What'd you say?
All right, if
That's
you want to be,
inappropriate.
let's change the topic.
You
If,
did to us.
first of all, you gotta have a policy and procedure, and you need to discuss that in your rules. So if you're gonna have, we're back to the special event thing, all right? Somebody wants to shoot off fireworks in the common areas, whether it's common in the HOA or owned in common in a condo, they should be making application, letting the board know what's going on, because all of a sudden, the board's, you're gonna get phone calls in the middle of the night, hey, somebody's out there at 3 AM doing that, so you need rules and regulations. Secondly, if you wanna have absolute control over this kind of stuff, you amend your documents and you put it in your Article 11 restrictions or Article 6, whatever it is, or your bylaws for your declaration. Amend your documents what you wanna prohibit. And if you wanna prohibit it, fine, but you're taking on the risk,
On
and
July 4th, there's homeowners out in our parks, which are, one of the, 12 acres, one was 18 acres. They're called the police. State police.
And the police tell them that they have to do it out in the street.
My
Not in
neighbor
their backyard.
has called the police every year on the guy that lives in back of him and nothing's done.
but not only
I'm
that,
not blaming the police department, because they got other things to do.
I mean, in essence, also, the person that's doing this is creating what's called an attractive nuisance. Because everybody will come from miles around and go, oh, this guy's got 6,000 pounds of stuff they went to Ohio and bought. And all of a sudden, you're gonna become the fairgrounds there. You wanna have control over those scenarios, either in your rules, but more specifically in your bylaws.
That gets back to my same point, is that when you have trouble selecting assessments in the first place, getting anything done, as far as policing anybody goes, it doesn't work. It doesn't work. The reality is that, and I'm not blaming anybody, I'm just saying that you got 8 members or 9 members on the board who have lives to live, and are gonna sit out in the park on July 4th, with their walkie-talkie and with the police department, say, Jack over here that lives on Kingsbridge is setting off fireworks in the park, you don't have permission. Reality tells you that's not gonna happen.
But again, what do the documents say? If there's nothing in the documents are silent, then what are you gonna do? You're gonna have to rely on the police to supervise every single incident that happens in the community, and they don't have the resources for that.
Again,
You're not dealing with reality.
But if it's in your documents, who's gonna enforce it?
Reality is the homeowners don't do
Homeowners
stuff.
Association can walk out and say, please don't do it, but there's no legal oomph behind that.
If
That-
it's
that's-
not a criminal matter, you're right, the cops, if they don't care, they don't care. I mean, if nobody's breaching the peace, it's a civil matter.
But if Jack
You
gets
can't
hurt,
specifically-
if Jack gets hurt, I wanna know that our associations aren't responsible because Jack got hurt doing that on the property.
Yeah.
So does Jack need to be told, you can't do this, or is it assumed he can't do it unless he received permission?
It depends on the association. What does your board want to do with your common areas? The board doesn't care, that's their decision. You know, the board regulates in a condo or an association, decides, subject to your documents, what is allowed and what's not. It's a judgment call, right? So if the board says, if the board says we do not want to allow this on common areas or common elements, that's their decision. How do you enforce it? That's a good question. You need fines, you need enforcement mechanisms in your documents, the ability to fine people for violations. That's a whole other thing because a lot of HOAs don't have any of that. So it's very hard to enforce that type of a violation because of its nature. But just as a matter of strictly speaking, can the board regulate that area or not? It's like anything else on the common areas. Yes, if your documents say the board has authority to decide what happens in your common areas, then yes, they can control fireworks as well. But if they don't care about that, if they don't want to raise a stink about it, and they have no objection to that, that's the board's decision. It's not illegal. Yeah. Yeah, you could do that. You could, then use your whatever remedies you have in the document. Subject, it's all subject to your documents. So, let's move on for fireworks.
Would the board be responsible, the association board be responsible for inaction, when notified that there's, a supposed violation of, those rules and regulations?
The question is, would the board be responsible for inaction if someone was claiming there was a violation of the governing documents in some way. Potentially, but I say potentially because, as I mentioned before, the board of directors has the authority to exercise reasonable business judgment in governing the association. And so how it responds to a particular perceived violation is something the board of directors is there to do. You may have situations where it's appropriate to simply send notice to an offender and say, you're doing this, it's not allowed, please stop. And that may be sufficient. In condominium associations, you'll frequently have a fines procedure in place where the board can levy fines against an offender for violating the provisions of the bylaws. So the board then can say, okay, we're going to send a notice, or we're going to levy a fine against this person because we sent notice and they're still doing it. Further, sometimes in documents, frequently in documents, the association will have the right of self-help to step in and abate a situation that is maintained contrary to the association documents. So if someone sets up a chicken pen on the association parkland, you can say, don't do that, we don't allow chickens, and that gets ignored. Perhaps you would levy a fine and the person still has the chickens. The self-help remedies provided for in association documents will enable the association to step in and abate the situation. So the association say, okay, we told you to stop, you're not supposed to do this, and so we're going to send our handyman in there and he's going to pull up all the chicken wire. Obviously, in that, every remedy that you exercise has its pluses and minuses. Further, on the heavy end of enforcement, you have in almost all condo associations the right for the association to take legal action, to file an action in the court to ask the court to order the person to cease and desist from whatever violation they're engaging in. So, okay, the chickens are still there, they're not supposed to be there, this person's not meeting their responsibilities under the bylaws. The board could decide to initiate legal action to get a court order to make that person stop. So all those remedies are typically available to associations, and how they are administered is left to the business judgment of the board of directors. So if there is inaction, perceived inaction, it might be the case that the board isn't exercising its power the way you think it should, but that's why you have a board of directors elected to make those tough decisions.
In that instance, since you brought up the idea of chickens, you might have it in your bylaws that you can't do that, but it's also a township ordinance that only certain properties have chickens. Can you then engage the police to have their action supersede even the board's action?
Yeah, that's a good question. And Richard, did you want to?
So with the question about chickens, that is an ordinance that we are enforcing. We do have about 18%, I believe it is, of the properties in Canton right now that can have fowl of some sort, turkeys, chickens, ducks. But it is also at the state level, we believe that they're trying to change it for several communities to have some sort of free range or cage-free chickens, but no roosters. So because of the noise, of course, but we are actively enforcing the removal of chickens almost daily.
I had no idea.
Yeah.
What I wanted to talk about is what you're all talking about, whether it's the bounce house or whether it's the fireworks or whether it's slip and fall in the snow. You're talking about premises liability versus common law negligence, okay? Decades ago, because I'm older, been doing this longer than Moses was in the desert, I was involved in a case involving Fox Chase condominiums where the person slipped and fell in the common elements. They sued the condo. The case was dismissed because the Court of Appeals said, you own in common, you can't sue yourself because you slipped and fell on your own property. That proposition is now being revisited. The Court of Appeals has decided to take a case to say, wait a minute, if you're in control of the common elements, whether it's a common area for a homeowners association or common elements for the condominium, and you have the responsibility to administer the affairs in either circumstance, you could be held accountable for what happens on that property. So that's why it's important to make sure that you have proper procedures in place. Talk to your insurance agent, talk to your attorney with reference to what you need to do in order to allow these things to happen. And as far as the other gentleman's comments with reference to enforcement and reality, the bottom line is if it's in the documents, circuit court judges are inclined, they will enforce it. It is a covenant. So you go through your procedures with fines and also amend your documents to make sure that fines are considered assessments, because you can't foreclose just for fines. But if you make the fines or other obligations as part of your amendments to your documents are considered and deemed to be assessments, you can pile that up and then you foreclose on it for the fines for them failing to comply. There are a lot of people out there who say, I don't care what you fine me because I'm going to do it whether it's $100 or $350. You get enough of it and make it worthwhile, you take it to circuit court, you get a foreclosure, and you get your attorney's fees.
All right, so the next question is about drones. If the association has a policy that prohibits the flying of drones within the community, and there's a Michigan law that they read that said that you can legally operate a drone in Michigan if the drone is in compliance with FAA regulations. So the first question is, how do you determine if a drone or a drone pilot is in compliance with FAA regulations?
We do have an hour, right? Oh, okay. All right, drones.
10 minutes.
Yeah, I'm going to try and do it in 4. Drones is probably where the OTARD rule was with reference to satellite dishes was 10 or 20 years ago. It's still a developing industry. Primarily, you got two different sources of authority. One is the FAA, obviously, and the other one is state law. Well, actually 3, because you've got your community documents and your bylaws typically, all right? What you're looking at for federal authority, most of their regulations are concerned about people. You're flying something over people, or you're flying in a protected area, or you're interfering with an airplane. So a lot of their laws are geared towards that, all right? That's not so much your concern other than other issues that I'm going to get to in a second. But what you want to look at is Section 49 U.S.C. 44809. Because we're talking about recreational use. So if it's less than 0.55 pounds, you can operate it under recreational use so long as you can comply with these 8 different provisions. It's basically for recreational use to be distinguished from commercial use. There's a number of provisions there, you can read them. If they're in compliance with that, then they can legally fly the drones, all right? However, they do need to register, and they do need to take what's called a trust course, it's TRUST course, so that everybody knows who's flying around where. The identity of the drone, they're supposed to be reporting that in terms of registration. Fortunately enough, the government got smart, and as of September 16, 2022, they were going to require all manufacturers to have these automated embedded things. So automatically the government will be able to pick up the ID of whatever drone is flying around. As of September of 23, everybody has to register if you're in the licensing situation. Now, if you're doing it recreational, obviously you don't need to have a license. But there's a lot of regulations there that really don't apply in terms of the operation of your association or your concerns. As far as the state law goes, there's several statutes that do apply to drones, and it talks about primarily stalking, harassment, sexual intimidation, sexual offenses. People that are on the Sex Offender Registration Act are not permitted to have drones or fly drones, all right? So most of the state regulations has to do with harassment, stalking, sex offenses. So that doesn't necessarily always help you. You want to know what you can do. Well, then we go to the third source, and that's your bylaws. Can you restrict them? Yes. I've got some community says we don't want drones in here whatsoever. If you put it in your bylaws and that's the way it is, that's what's capably enforced. The question being is how you're going to be able to enforce it if you don't know who's flying it and so on and so forth. So the better procedure is put something in the bylaws, and in all my amendments, I have a total section on drones in terms of how they need to comply. They have to fly lower than 400 feet. They need not be within 50 feet of a dwelling unit. They can't be utilized to spy on persons or people and so forth. And you can itemize all these prohibitions in your bylaw, and then if you find out who is doing it, if you can call the police or you can call an FAA official. If they have to have a registration certificate on them, at least that it's been registered so that you can control that kind of thing. There are severe penalties for FAA if you're flying drones and you don't have it registered, all right? But you want something in your documents. Again, we're going back to amending documents. I think Tracy's going to talk about that in a little bit. In terms of addressing it now. You don't wait till after the fact. You do your amendments to your documents and be proactive about it. And what you're concerned about, and I had a whole list of things, privacy, security, the same things that are in the state statute with harassment. You don't want, they've changed the time period. It's 1 hour before daylight, 1 hour after daylight. It used to be a half an hour. And you need to be theoretically 16 years old. It used to be 13 and they raised it to 16 years old. So there are some regulations. It's just a matter that they're out there flying and you don't know who they are or where they came from. So unfortunately, it's up to the board to try and figure this out kind of almost after the fact, as far as that goes. But if there's something in your documents, I've had several situations where people have been flying the drones over the back limited common elements because they're checking on people. Now you have to distinguish recreational with commercial. You can't have the safe harbor protection under Section 107 if you're operating under commercial circumstance. Theoretically, even when your realtor does a drone, that is not recreational, that is commercial. So you can't have the federal protections to comply with those 8 things if you're operating it in a commercial fashion, if you understand that distinction. So the other thing you want in your bylaws is to make exceptions, but you want to have a procedure in place so that if someone's going to list and sell their house, I mean, most of the time now you see the realtors, they go, well, we got a 3D thing in the house and we got a drone that flies over, shows all the property. That's fine so long as they follow the procedures that have been set forth the board. You want to know who's doing it, what hours of operation, when they're going to do it. Can't be too much noise, can't be late at night, can't be too early in the morning. You need the rules, and then they come and let you know. It's the same thing like if you're going to have open houses for sale and so on and so forth. You've got rules and procedures. You want to know what's going on. So that's about it.
I'm curious, what does Canton do, if anything, on drones, as far as ordinances and whatnot? Anything?
As far as the ordinance goes, we don't do anything with, we'll pass them on. If we pass them on to PD, would go to our lieutenant, and most likely we'll pass it on to Wayne County or to the Michigan State Police.
So you pass that to?
Yeah, we don't deal with drones at our level at all.
Any questions on any of that? I know I kind of threw a lot at you real quick.
All right, really quick, I'm gonna go to marijuana. A board was notified that co-owners were growing marijuana plants on driveways, decks, or patios. Can the board enact a policy that marijuana plants cannot be grown or placed in common areas or in plain view? And if yes, can the board send violation letters if co-owners violate the policy?
Well, let's light up here. Marijuana smoking is legal, right? Tobacco smoking, legal, right? Alcohol consumption, legal, right? So people have a right to do those things. Can you stop? Yeah, what's the problem? Hey, lighten up. You know, so I think people look at this and they say, okay, well, they have a right to smoke marijuana, but that's not unfettered, you know? You can place restrictions on that. Let's look at tobacco smoke. I modified the bylaws for a condominium association in Ann Arbor, of course, where they banned tobacco smoking in the condominium, the whole place, inside the units, outside. You go out there, there's a sign in front of the condominium proudly proclaiming, "We are a smoke-free campus." People have a right to smoke cigarettes, don't they? But that's a private community. You as a community can come together and change your bylaws to say no smoking here. And as a matter of fact, they grandfathered 3 unit owners who were smokers, but all 3 of them really stopped smoking. So just because something is legal doesn't mean that you can't regulate it or even prohibit it. Marijuana smoking, okay? Same thing could happen. You as a community can decide, we don't allow that here, even though it is legal. So you could have a marijuana-free community if you chose to do so. What I'm seeing is communities are really having concerns about grow houses. And from what I understand, they really stink, just to high heaven, that it'll turn your stomach over. And the grow house is a commercial use, and so there are a lot of reasons why people shouldn't be doing that. But we've had communities say, okay, let's come down hard on that, and let's amend our documents to say absolutely no grow houses are allowed here. So if someone does operate a grow house that's against the bylaws, and you have your remedies to pursue them. And then the law itself, for personal use, okay, someone's not operating a grow house, they can have their personal plants in their unit and that sort of thing. Yeah, that's okay. But they're not entitled to have those things out on the common areas or in public view. It has to be secured. So they have the right, but there are restrictions on that, and you as private communities have the ability to do what you want to do to make your community smell the way you want it to. Yes?
Constitutes public view. Like for marijuana, I mean, can you have it on, that was my question. We have people growing it on their decks and in pots.
I think it's got to be enclosed.
Yeah, it's got to be enclosed and secured. So no, that's
On your deck is not allowed, on the driveway is not allowed.
at your community. You have people doing that.
We got lots.
The law is
Come
that
smell.
No kidding.
if it can be seen by public, right?
Yeah.
So if you are walking around a community, if you can see into their backyard, then that's public view. If you can't see into their backyard, that's not public view. You seeing somebody else's backyard, that's not public view.
We did call Canton Township Police, and the police said that they would come out and require the homeowners to move their pots inside. But that's the point why they're outside, is because that's how they're growing.
Right.
And we chose not to do that yet, to take it that way. We wanted perhaps to do it our way, by sending a notification. So it doesn't have to be in our bylaws, it can be in our policies, which is our policy like an extrapolation of our bylaws?
Yes, it is.
Okay, so as long as we put it as the board of directors in our policy, it's a rule and we can hold them accountable.
Yes, and of course, I know that you're sending notice of these policies out to everybody in your community saying the board has decided this policy and everybody has to abide by it.
Okay, we're gonna have dozens of angry people.
Wow.
But there are the law identifies where you can have the plants, and they can't be in public view, like we were talking about. So especially where you're concerned, backyards may be viewed from the golf course, so that could be a public view. If you're golfing on the golf course and you look over and you see all these plants, that's certainly an issue.
I don't know if that'd be public view. You're right.
Public golf course?
We're talking about growing, though. We're just talking about growing.
They're growing it.
Yeah, there's specific rules about all that in the statute, and I don't know them all off the top of my head. But I thought part of it was they had to be secured. But if you're talking about, in a condo or an HOA, I would prefer, Ed says you could do it in rules. Is this condo we're talking about?
Yeah.
Technically, yeah, you could create rules to address it, but I would be concerned if there's nothing in the documents talking about marijuana at all, if somebody would challenge that and say, you know, why are you prohibiting this and not something else? You
You
know?
mean the bylaws? Is that what you mean by the governing document?
Well, I'm saying you guys are talking about rules and regulations, or rules and regulations, which is different from bylaws. So rules and regulations can be changed at any time by any board. Well, rules and regs technically are, if you're a condominium, they're part of the condominium document, so they can be enforced just like bylaws can. How do you enforce them? You could do fines for violations, the whole fine process. You could file suit, you know, all the abatement, all the remedies that you would have. You know, but
Why not just send a reminder to people in the community that state law or the state, whatever the state
well,
that prohibits.
yeah, but I mean, if we're talking about how do we enforce it privately as a community, or what do we want our private rules to be, you can do a rule, but I would prefer something that's a hot topic, controversial. I always push the boards to do a bylaw amendment, because then it's voted on by everybody. You have to have 2/3 supermajority approve it, and it can't be, it's very hard to challenge. You know, so if you're going to do something like that, or like a rental cap or something, rental ban, you got to do bylaw amendments. You know, I would have the community vote on whether you're going to, if you're going to have strong regulations about where you can use marijuana, smoke cigarettes, things like that. That'd be my preference.
I just, off the topic
Yeah.
question, rental cap, is there a threshold for rental cap for condominiums?
Rental caps. I do a lot of rental caps, and there's no like state, you know, mandated requirement or anything like that. I mean, the Condo Act's wide open. Just says you can amend your leasing restrictions to adopt, or you could change your bylaws to adopt or amend leasing restrictions. What we look at usually is, I think, like mortgage voting or mortgage companies' requirements, because we saw a lot of problems after the recession with people not being able to get mortgages because they had too many rentals in the community. So looking at that, you know, the requirement is, it's not like super onerous, you know, but usually if you get above 20%, 25%, 30%, you start having problems with a lot of mortgage companies, and you start hearing about problems in the community. Also, there could be problems with insurance going up with if you have too many rentals. You know, I've been told the premiums could double or triple because you'll be treated like an apartment complex. So, where did I get this information? I've just been doing this for 20 years, so you know. Well, good. I'm sorry. Yeah, in front of you, yes.
So in order to get a bylaw change, I need 55% of the entire homeowners to agree to it, or 2/3?
In a condo, it's 2/3 of all the.
Talk to each other. We don't talk to each
Yeah.
other at all. They haven't gotten together as a group for 22 years.
Yeah. It can be challenging, but it's not impossible. We do it all the time.
So far, it's been just about impossible, but rules and regulations can be established and implemented by the board.
Yes, rules and regs. That's different from bylaws. Yeah.
I'm just trying to figure out where my authority base or the authority base of the board lies. We need some things corrected, and to make the rules and regulations, we're okay.
It depends on, it's fact specific. It depends on what the exact issue is and what your bylaws say about your rulemaking power. What do you have power to regulate? Usually it says about use of the common areas. That's pretty common. Usually it'll mention units as well, but that's where it comes from. But it depends on what the issue is as far as, you know, can we do it all just through rules? Sometimes you can and sometimes you can't. You know, it depends on, you know, if you want it to be something more or less permanent, and you want it to be a public record, and you're afraid it might create a big problem in the community, do it as a bylaw amendment. Those are my three considerations that I look at, because if you do it as a rule, it's not going to be public because it's not recorded, usually, with the Register of Deeds. It can be changed at any time by the current board or by the next board because, you know, the board flips and they just rescind the rule, so now it's gone, right? And if it's adopted as a bylaw, as I said earlier, it's approved by 2/3, so you can't challenge that. Like somebody could try to challenge a rule and say your rule is arbitrary. Okay, that can be done because it's like, well, you just adopted this rule. There was no vote of the community. So you adopt this rule. The rule has to be reasonable and not arbitrary. So there are considerations as to what the issue is, whether I would recommend it should be a rule or a bylaw. It depends. That'd be my thought.
Is it okay? I'm sorry. Let's do your question first. Your question's more important than me.
Okay, this is about a clubhouse. For 27 years, the co-owners had the control of the clubhouse to attend meetings, at parties, or whatever. And then the new board came in and they stopped our communication with the clubhouse. We're not allowed to use it. If we want to go to a board meeting, we days ahead of time and give a reason for that we want to attend, and only 2 people can go. They can speak for 15 minutes, and then when they're done speaking, they leave and the door is locked to the clubhouse. We cannot attend any meetings as an open clubhouse. We can't log in at any time because it's locked all the time. And so my co-owners, they told me to come to this meeting. I'm on the board. I've been on it before, but I am one person fighting against 6 other women because they will not consent to open the clubhouse. We can't have a get-together. If we want to rent it, the co-owners, we have to pay $100 to rent our clubhouse. And we don't know what to do about it because we can't go to the meetings and talk to the board about it because they won't let us in.
All the board meetings are closed.
I just became, 6 years ago, I was on for 6 years, but this board has set up all these rules and regulations now, and they know what to do, but they just.
Well, my initial response is you need to look at doing a recall of the board of directors.
They say, Carolyn, where's our money going? What about this and that? Because they don't go to the meetings, and when we had the meetings, the treasurer would give the report, so we knew where the money was going and how much was there in reserves. Now, we know nothing.
Don't you have an annual?
Well, yeah, you need to like vote your board out or do a recall. But there's a lot of things you can do. You could do a Section 2487 request in terms of they must make documents available to you. So there's a lot of things. Much of a board that's themselves, you need to take those people out of office for all your things. But I want to go back, and I'll let somebody else address that further. But I want to go back to this thing about marijuana because it's more than just the marijuana. For one thing, in terms of what happens with marijuana, I have what I call the Las Vegas rule. When I amend the documents, I say what happens in your unit stays in your unit. Regardless of whether it's marijuana or it's cooking smells or excess noise, it needs to stay in your unit. I've enforced that before. I've required a co-owner to go and purchase an air purifier system to make sure that it didn't leave their unit. Okay, so you need, again, you can amend your documents and to address these kinds of concerns. As far as the distinction for this gentleman between rules and bylaws, like Greg says, a lot of times the judge will say, Richard, show me where it says that. What page? What paragraph? I don't want to read this 100 pages. Where's it at? I say it's article, section, and these are recorded. If you do it by a rule or regulation, he's going to go, how do you know they even got this? Show me proof that it was published. Show me proof that they got it when they bought. You don't have anything. If it's in the bylaw, it's in public record, and the state law presumes that they've got actual knowledge of it. So it's always better to amend your bylaws to do it. The other big thing about marijuana and your growing concerns, I've got a community, their water bill went from $1,000 a month to $3,000 a month. Guess why? Their electric charges for that building. So if you're a community and you're in a condo where you furnish utilities, water and electric, and all of a sudden your bills are spiking like crazy, you got something going on there that you might want to investigate and get a court order if you need to. You ask to do an inspection under your right of inspection under your documents. If they don't do it, then you got to go to circuit court, because otherwise you're going to be paying $3,000 a month forever until you stop it.
I'll go ahead and address your question, ma'am. What can you do? Richard already mentioned board recall. If this board is drafting rules and regulations that more than a majority of the community doesn't like, most likely your documents has that ability to overturn rules and regulations. Check in your Article 6 provisions about the rules and regulations. That's generally where they're going to be. That even if a board adopts a rule and regulation, if majority of the co-owners who are eligible to vote to turn it down and reject it, they can. Also, I mean, if you've got that many community members saying that they want to attend these meetings and they're not getting the information, call for a special meeting, and there's going to be.
We have 160 units of people in that building.
And when you as a board member address the rest of the board, these ladies are just simply saying, no, we're just not going to share this information with the rest?
We haven't had our first meeting yet. It was just
Okay, and that's when you got on the board. But these meetings have been closed for a while now.
Ever since COVID, they stopped it then, and they never opened it up from there on.
Well, it's, at some point, maybe your attorney needs to get involved for your community, but we recommend, transparency for the board.
Tracy, there's a gentleman in the back.
But anyway, there are a lot of options for you to, as a co-owner, to get the information that you're requesting. We recommend that the board open the meetings, obviously not for the executive session where you're talking about litigation matters or violations or delinquencies.
We always had open meetings, and they would have the treasurer's report, and, all the minutes and anything coming from the co-owners. And then in our section, when it was over, then the board would have their private meeting afterwards.
Well, as a new board member, you need to push your fellow board members to reopen those meetings. Sir, question in the back?
She was just saying that most associates do that. Part of me may be open, but when they start talking about private things, then it's closed. All non-board members are cast for the.
And that's customary.
That's what most all are like that.
Right, and I kn-
Not everybody, but yeah.
General membership meeting.
I heard the word Open Meetings Act thrown out there. That doesn't apply to a community association. There's no requirement that the meetings be open. We recommend that they do for transparency purposes. And, you should be getting all the information as far as the budget and where your money's going at the annual meeting. Sir?
There's no way to force that.
Oh, there are.
I have work in
Good question.
Oh, you did?
The condo HOA association I belong to and the management company that they work with, they do not have annual meetings. And, so we don't find out about their budget until the end of the year when they send out the information to the co-owners. And, we had one in 18, we didn't have one in 19, didn't have one in 20 because of COVID, had one last year, have not had one this year. So what recourse do the co-owners have when we have a board and a board that works with a management company that, is not transparent and just does what they want to do?
Your recourse is to elect a different board, get people together who are concerned to act together, put a slate of candidates together that say this is the way we think we should govern ourselves, and I will assume that your governing documents will require that you have an annual meeting.
I believe it's in the master deed. I haven't seen the master deed, but are there any state rules, regulations that state that a homeowners association has to meet during the annual period? Or
No, those are going to be in your bylaws
Nonprofit
for your annual meeting. In the Nonprofit Act.
Corporation Act, there is a requirement about having an annual meeting every year, yeah. So it is in there, it's not in the Condo Act.
But and you have ways of enforcing that. For example, if the board will not schedule a meeting, then you can, typically, you'll find in your documents that, say 1/3 of the co-owners sign a petition and present that to the board, that will require the board to schedule a special meeting to address the matters that were brought to the board's attention in that petition. And ultimately, some of the remedies, if the board just isn't doing what it's required to do, I said, typically you'll have a provision that you can recall all or some of the board members That's going to require the vote of a majority of the members to recall those members and then elect a new board. Or you wait till an annual meeting and then, elect new board members then. So I think the theory underlying all of this is that the power flows from the membership. That's where the power to govern comes from. And so the board is serving at the pleasure of its members. And if most of the members don't want the board, they will have the right to recall them. But then the reality is to get people motivated to act. So you got to get people organized and working together to petition to have a special meeting called. Ultimately, if they're just ignoring the law, you also would have the remedy of filing an action in court to get a court order to require that the board follow the law.
I had to get 20 people to chip in, hire a lawyer,
Yeah.
to force the meeting, because it had been 4 years,
Yeah.
and I knew that nothing was getting taken care of, he wouldn't provide any financials, nothing. I knew he wasn't paying a landscaper, talked to the actual landscaper, I got all the invoices from the landscaper, I know it's collected, and I know it was going out, and, yeah.
Well, we get our
Lots
HOA,
and lots of money.
yeah, we get our HOA dues raised 10%, and we don't have an annual meeting. And our HOA dues
The lots raised ours.
increase have doubled since I moved in there, so, we've got a management company that says, we gotta make more money. And then they have a rubber stamp, HOA board, which is what I think they are, and they just,
Well, I will
Don't-
say like a big chunk of your money's probably going in the management companies because we looked into that and that costs
Yes,
a lot of money, especially nowadays.
Unless you're a president who just pays yourself $985 a month for 30
How about that?
months. That's pretty good job, eh?
anyway, that's what's going on.
President paid himself $985 a month. There were invoices for 39 months. But you never saw the amount of the invoice taken out of the bank.
I want that job.
Hundreds of
I volunteer.
Hundreds of hours.
I volunteer to be on the board.
Thousands of dollars in money transferred everywhere.
I'm curious, I missed the, what was the reason he said they didn't
I
have
have a
annual
question, what do you do?
They just didn't. They didn't
So
schedule it.
I'm still part of the HOA. I no longer live there, but I still try to help out because we have an issue with the new HOA that part of the HOA. Nobody wants to help. Nobody wants to. So it's only been me. I'm the vice
God bless you.
and she lives there, so obviously I care because she still lives there, but now it's just her. She's my treasurer. But now, my question is, what do you do when you have people in the neighborhood that don't want to be part of the HOA, that don't want to help, keep the landscaping, do the snow, detention? What do you do when people just don't want to help out? And now it's just
Right,
her.
I can't, obviously creating invoices, I had to recreate all records.
We have a new
I got
president,
nothing. I had to get
she's not
tax-
here, we
tax
have a new
records.
secretary, they're MIA most of the time, and it's always just been me and her. And while I was helping her, we both kind of bounced ideas off each other and things like that, but the other two were just useless, I hate to put it like that, they were just no help. And now that I'm not there anymore, it's just her, so what do you do in situations where people in the neighborhood just don't want to be part, don't want to help, don't care?
Get community.
What are the big jobs that you guys are responsible for? What items that?
Well, right now, the big issue that we had this past year was snow companies. They weren't as efficient, so, getting quotes for snow companies, sometimes they would drop us and we would need to find somebody else. Landscapers, it was the same issue. We don't
Getting
have
quotes. and
Getting quotes.
We have a lot of, we have a lot of clean up from 5 years of neglect.
Yeah.
Our money wasn't being spent on what it was supposed to,
We're a new board.
we're collecting 23.
Yeah, I think we got your email about this issue before the.
23,000 a year, and then
Well,
we just got paid
It's, I mean, I'm just thinking if nothing's getting done, people aren't upset about that. If things are not, I mean, everything's still getting done. What is the?
Once we took over, we started taking care of things, but the previous board, to give you a little background, wasn't taking care of anything. So the meetings had to be forced with a lawyer, because we had the issue that the gentleman back there had.
Okay.
They weren't doing meetings, so we got a lawyer and we were able to take over. And once we looked at the financials, there's big concerns. And now we're just trying to fix everything that the last board didn't take care of. And,
Yeah.
ponds, we weren't looked at for 5 years.
Yeah. I mean, it's a very common problem for both condos and HOAs. Just people are apathetic and they don't want to get involved. And, so you're not alone.
Still on the hook because I no longer live.
Well, you don't live there anymore, so it's her and that's it.
Well, they are all
That's
over
lonely.
the website, so their names are.
Yeah.
Still on the Lara site, and
I mean, I would just keep trying to get people to volunteer for the board. That's one thing.
I'm just gonna put it to them.
Yeah. I mean, there are ways to go to court to have a judge.
what can be done if she just decides to quit? That's the point.
Well,
Like, I'm done if nobody
I don't think we would recommend that because once you're in the seat, then it's like, okay, well, technically, right. It's like you got to still have legal duties that you have to fulfill.
You
And,
said you had, 120 other people sign a petition or fund a lawyer?
No, he said that.
No, 10 people.
10 people?
20 people.
20 people?
No,
So
yeah.
where are those 20 people? Go to those 20 people. They cared enough to fund
I'm the
the
type of
lawsuit.
person, people walk by my house, I stop and talk to people all the time. I just met someone the other day, so I do try, I have a lot, I mean, I've been.
You're saying they
I've
cared
been
enough
dealing
to
with this
fund the
for over
lawsuit.
3 years now, to try to uncover and
Well, a
get
lot
this
of
straight
them
again.
didn't want their names because when we went to court, they didn't want their names on because they were clients of the lawyer that we, got. They didn't want their names on the lawsuit as well. They were willing to give the money to help, because they knew that there were issues that needed attention. But just a lot of them were good with helping out that way. But further than that, they just, they don't want to decide.
gentleman in the blue shirt had a comment.
Comment.
Yeah.
I served on the school board for Garden City for 14 years, and probably, I think I can recall all but one election I was unopposed. It's unfortunately, just like in the schools as well as the condos, if I found out, this is my second year, and when I first moved in, we had one person that was our board president, and she was running for about 3-4 months, and they put out a notice that they sent out once a year with the annual budget. And they said, volunteers, welcome, contact us. So I volunteered. So for 2 months, there was 2 of us. And then when we had our annual meeting last September, we asked for more, and we were lucky to get 2 more. So now we're up to 4. But we're Links at Fellows Creek. It's 200 and some units, and we can't even get, I would think 7 is probably the right number. 5 or 7, you always want the odd number. But it's a shame that when something goes wrong, they're one of the ones there are really quick to complain about something, but when you ask them, would you be willing to help them? I don't want to help.
That's how it always is.
You just got to keep after it and try and recruit and get, it's a painful process that I'm learning
I mean,
too.
I feel like I recruited the people that we got, but then they don't do the job.
Have you tried appointing people to the board under your documents? You have the power to appoint to fill vacancies, right? Probably. So bylaws, you have bylaws?
We have bylaws.
Oh, is there anything in there about? Okay, well, if you're a corporation, you still have the power under the act to fill vacancies, usually to appoint people in the interim. Yeah, so I mean, I'd push for that. Try to appoint people if you get volunteers. Get the word out that you need volunteers.
I have to do that too, you see, so I
Yeah, it's hard. I mean, it's not easy, especially at HOA.
literally have
Yeah, it's just, but it's your community. Ultimately, you guys are responsible for your own community. It's like people have to take some initiative and get involved. Well, you're not, so you're fine. But
She just doesn't drink wine every now.
yeah, that's the easy part.
Let's move on. Yes, sir.
Just a quick comment. Is it an option to say that we're looking into hiring a management company? It's gonna cost everyone a lot more money if we don't get volunteers.
Yeah, I do plan to do that.
So, all right, you're all gonna pay hundreds more a month,
Yeah.
or you step up and help?
That's what I'm saying, like, when I looked into it, and it was very expensive, because we're gonna have to raise dues.
I
Not
know
willing to
places
help.
that have done that, and because they couldn't get help.
Right,
And it's really not that difficult.
but I bet
Okay, let's look at the violations that fail to properly maintain their property. Can we find them? No, you can't evict owners. They're the owners. But we talked about the remedies that are available to communities, and that might be, as been suggested, a letter. You know, start with a letter. If you have a fines procedure in your governing documents, then you can fine people. You can use self-help under some circumstances or take them to court. And typically your documents will provide that you know, the violator is responsible for reimbursing the association for the attorney's fees incurred in enforcing. So it's the violators end up paying. So you have those different means of enforcement, and it's up to the board of directors to decide which means would be most effective and most reasonable. You know, you get the extremes, like I said, well, why not just send a letter, you know, and just ask them, maybe they will comply. You know, yeah, the nice way, and then on the other end of the spectrum, just sue them. Sue them, take them to court, sue them. And, you know, so it's up to the board of directors to decide where in that spectrum what kind of powers you're going to use to address violations. Does a township hold associations responsible for maintaining neighborhood standards and township ordinances? Typically, you'll see in the governing documents for communities that the township has the right to step in if the community isn't doing its job to maintain. I've not seen Canton Township do it. It's theoretically there. I mean, do you see any instances of that?
Yeah, we do step in. It's not super common for us to step in, but we will reach out to HOAs if we see an issue that, I guess most common is trees and common areas for the HOAs. But with snow plowing, we also step in. There's not a whole lot that we generally do. We do have, I just actually finished a case with one where they had a common bridge, and it was graffitied and nobody wanted to take care of it. So we had to step in, and they ended up having to take care of it. Before we got too far into it, they stepped up and just took care of it anyways. So we do step in if we see things that are being neglected. But for the most part, we don't enforce anything on an HOA. We try to find a way to pass it down to the owners.
As an example, if somebody is not cutting their permits,
Right.
is that something that the ordinance department could help us with?
Oh, absolutely. We could enforce that, but it would be enforced onto the property owner, not the HOA, unless it was in a median or a common area or something of that nature. Then we would reach out to an HOA, but that doesn't. I mean, we don't really have any of that. We don't see any HOAs that aren't taking care of their own properties. Yeah, homeowners, we definitely do. Yes, reach out to whichever zone you're in. I got a map up here. Reach out, and we will step up and take care of that for you. Absolutely.
And Bill, what does the township do if there's cars stored in driveways that are covered or never driven? Like, does the township enforce any of that, or is it up to the association?
So we will enforce unlicensed or inoperable vehicles. When they're covered, it does get tricky because we are not going to go get a warrant to uncover their vehicle to check their license plate. If we can't see a plate, if it's backed in, unless we're invited to look at it, we are kind of stuck with trusting that it's licensed. But if it's inoperable, which means it cannot be driven, if it has a flat tire, it's up on blocks, obvious damage is done to it where it can't be driven, then we definitely jump in. But there's not a number of vehicles. There's you can't park anywhere on a grass. So if you got a driveway that's 2 cars wide and you want to get a third car there and you kind of overlap both sides, we definitely step in and say, you know, you got to stay on your concrete. But as far as uncovering a vehicle and checking it, or the number of vehicles, or how long it sat there, we're not going to jump in there and tell them they have to uncover it and prove to us that they can be operable.
I just wondered if we have in our bylaws, or I think our bylaws, that say that you should have your cars inside the garage, or, you know, have one out, you know, but there's a homeowner who has his garage is full of stuff, which he keeps it closed, the door closed, but there are two cars parked in the driveway at all times. They're not broken down or anything, and then he parks his truck in the street. So is there anything, I mean, our association has asked, you know, please, you know, but, I mean, what happens if he gets like 2 more cars parked?
Yeah, because it's not an ordinance for Canton Township, we're not going to step in. We probably won't even give you guidance on that. Sorry.
Yeah, you can follow the violation procedures, and if they keep doing it, you will find procedures in there, you can find them, and then if they keep still persisting, you can, if your documents allow, you can take them to court for enforcement of that.
You have private roads?
Yes.
Okay, so you probably, if it's a violation, possibly you could tow that, if you have that in your documents.
That's a tough one.
Yeah, so that's,
Based on modifications.
You said covered car, but what about recreational vehicles and boats that are parked in the driveway for weeks and weeks? That's Canton ordinance, is not.
Kind of. So Canton ordinance for recreational vehicles, utility trailers, boats, anything of that nature, it can be in the driveway for as long as you want, as long as it's behind the front line of the house. So anybody that has a house that their driveway extends past the front line, they can park it back there and they can have it there for an extended amount of time. We can only enforce our ordinance, so I've dealt with this several times. We'll have a conversation with them. I'm sorry?
How would we enforce that?
If you
Anybody
go
got
to the
that?
remedies section of your documents to determine what your remedies are. Can you find them? Can you take them to court? What are your remedies?
Right.
All right, and really quick, while you have the microphone, Bill, do you know if it's necessary for people to get approval from their association to do a modification if it requires a permit first before the township is providing permits?
We actually just changed this rule for the building department that we do not require HOA approvals for any permits, but any work being done, I would definitely check with the building department. We've run into a lot now that my HOA said it's okay, so we started doing work, and I did not pull a permit, and now we're in court. So I would definitely make sure we are enforcing that.
Did the association report the failure to secure a permit to you?
Yes, absolutely. Yeah, that's us or the building department. You can report it to us. We go out daily to reports of permit violations. Keep in mind that we don't have access to inside of houses. So if someone reports to me, hey, I know this guy is working on his basement because I was over there over the weekend and I saw work being done, I have to rely on him either being faulty and leaving everything outside and I have proof, or him letting me in or her letting me in. So it's a little more difficult for us to enforce something like that. Yep.
Thank you. So we're in a condo association, and one of the co-owners has just built a deck, he has the permit. However, when the final inspection came through, there was a sticker, I what color it was, put on his door wall.
Okay.
That it failed
Mm-hmm.
for certain items.
Mm-hmm.
Does the township go back and check on that, or is that up to, if you know what the timeframe is? But I didn't see any specific date or timeframe he had to rectify those violations.
It would be specific to the job, whatever the building inspector would have wrote on there for his time frame. So depends on what he was written up for. I mean, specific to that, if we could look it up in our programs, see what the rules are, see what the time frame he gave, and get back to you.
Almost out of time, but with regard to tenants, what can you do to regulate activities of tenants? That is done through the property owner typically. They are responsible for the conduct of their tenant. So typically in your bylaws, you'll have a provision that you will send notice to the owner of the property and say, your tenant is not following the governing documents requirements, and they have 15 days to make sure that they secure the compliance of their tenant. So it's up to the owner to enforce that behavior of their tenants. If the owner fails to do that, then you typically will have a provision in your bylaws that allows the association to go to the extent of even evicting that tenant for violating the provisions of the governing documents. What can you do to regulate rentals? Can you have a rental cap? You bet. You can set your rental cap where you want. Some communities will say no rentals at all. Some people will look to say restrict it to a percentage. Sometimes it gets too far afield, and it may be the case that half the units are already rented out. Well, it's difficult to get the 2/3 of the community to vote in favor of restricting rentals when half of the owners are invested as landlords. I've made that happen. You have to do the politics to change your bylaws to make that happen, but it is possible to adopt a rental cap.
And is rental and leasing the same?
Yeah.
I just want to add one thing about rental. The legal definition of a rental unit or a rental home is when that dwelling or that home or unit is solely occupied by someone who is not on title. So this comes up a lot of times when we do our amendment projects and we do informational meetings with the co-owners. And the co-owner will say, well, my son lives there, so it's not a rental. Well, then the question is, who's on title? Is your son on title or are you? Well, I am, but my son's living there and he's a family member. Doesn't matter. If he doesn't have a present ownership interest in that unit, he is a non-co-owner occupant, that's a rental unit. And Canton Township will back that up too, that if you're not on title, it's a rental and subject to all the rental provisions.
Okay.
One quick question, good question about the rentals. If we know of one that, are they supposed to notify you guys? A co-owner wants to rent to somebody, okay? And does that co-owner contact Canton and say, we have a renter in here and you guys come out like once a year or something?
Yeah, you contact the building department. They have 2 rental inspectors that will come out, and they have to get listed as a rental before they can even occupy it.
Okay, yeah. Half of the 2 units that we saw a sticker from Canton in there.
Yep.
So somehow Canton must have known that that was a rental unit, and they came out there and said, please don't rent again until you contact the building.
Yeah,
Okay.
exactly.
All right, thank you.
Just a question, we don't allow rentals in our homeowners bylaws, but how would you, sometimes it's hard to know it's a rental. Like, you don't talk to those people,
Yes.
we don't know them, so they're in there renting for a long time without anyone ever in them.
At your annual meeting, I'm sure have a requirement that everyone fills out your property information sheet and emergency contacts. If you don't, you should. And that's gonna be your source of information about who's occupying that home.
Well, that's,
But
the
not
one I was
everyone
thinking of,
fills
the
that
owner,
out.
wasn't
Well-
in town, filled all that out with his name and wasn't there.
Another thing you can do is contact the assessor to see whether a homestead exemption is being claimed on the property. And that's something you can get readily. Go to the assessor and say, is there a homestead exemption claimed? If not, then there's a red flag that person is claiming their homestead somewhere else because they're renting that property out.
And that information's online. Canton Township is great. The assessing information is great online, so you won't even have to call their office. You can get that up online.
So the homeowners that are renting out their units, are they in violation of the law if they're not reporting to the township that, so we've got, I know in my community, which has transitioned from almost, obviously initially it was all owners, but over time, it might be as much as 40% rentals at this point in time. And I know for a fact that the landlords or the owners of the property are not going to the township and they're telling you that they're renting out the unit. So what recourse do us, I'm an owner, us co-owners who want to maintain the, financial viability of our community over time, what recourse do we have in regards to holding those people accountable for their obvious intent of not going to the township and, facing the property inspections that they have to face?
I would say report it. That's the number one thing. That's the only way we're gonna find out, for the most part, is if someone reports it, and then we look into it, and we can go take care of our process.
Would they be fined for?
Yeah, there's a process we go through, not necessarily fined unless they go to court for it, but they will restrict their C of O, so they can't occupy the premises. So, there's ways for us to get them to comply. Most of them will just comply and list it as a rental.
As far as the condo association is concerned, you can issue a bylaw violation. There's a couple of ways. I mean, you could issue a bylaw violation that the co-owner failed to follow the bylaws regarding renting the unit. You can also go the route of a tenant violation, because there are more restrictions and more remedies that the association, a condo association, has with a bad tenant versus a bad owner. The Condo Act and the documents for your association say that it's possible to evict that tenant for violating the bylaws. I found that issuing a tenant violation letter to the landlord co-owner gets more response quicker, because then if we kick out that tenant, that landlord co-owner doesn't have that income anymore. So they're gonna step up and do what they need to do.
Well, that information is held by the management company. And so the management company really doesn't care as long as the owner of the property continues to pay, whatever the mortgage states that they have to pay, as long as they're up, and they pay, I'm sorry, they pay the HOA dues that they're required to pay monthly. So that's part of the problem.
Well, I would say change your property management company and contact your association's attorney directly, and that attorney can step in and take care of these violations.
So they could draw up a suit against the management company?
No, that's not what I'm saying. I'm saying you, as the board, can fire that property management company or not renew their contract, change property management companies, but in the interim, if you've got violations that are not being acted on by the management company, the association's attorney can assist you with the remedies under those violations.
Association's attorney.
Yes,
So we should have an association's attorney.
you should.
All right, so we're unfortunately out of time. I know another topic people have questions on was association document amendments. If you go to our YouTube channel, ZDF Condo and HOA Attorneys, we have a presentation that solely speaks to amendments of documents. And then in your packet, you've got all of our phone numbers and email addresses. Please feel free to send us an email, talk to us afterwards. And thank you all for coming. Thank you.